Hi there, welcome to another edition of SEN Unplugged. My name is Mark Small, solicitor, and today what we're going to talk about is how you go about completing the forms if you want to appeal to the SEN Tribunal. So you'll have to bear with me with this particular edition because I'm going to actually do the demo on screen so you can see how you fill in the forms and what kind of content you need to produce. Okay, so let's see how we get on here. So what we're going to first do is, if you go into your search engine, and in the very top you'll see there's reference there to the SENDIST, so SENDIST. If you type that into Google, that will bring you up to a home page, which you'll see the very first thing that comes up is called the First Tier Tribunal, Special Educational Needs and Disability. Now, that's where you can lodge your appeal if you're unhappy with the local authority's decision, and the tribunal can hear appeals against a range of things, including challenging refusals to carry out EH needs assessments or reassessments of special needs, challenging the contents of the Education, Health and Care Plan, either when it's first issued or at annual review, challenging the cessation of the EHC plan. Those are some of the key things that tribunals will look at, and you'll get the information from the tribunal when you receive your decision from the local authority, either following an annual review or following the issuing of the actual Education, Health and Care Plan itself, or if they've refused to carry out an assessment, you'll get a particular letter from them at that point. So those are the kind of circumstances where you can then be brought into this process. Now, we're going to do separate videos on mediation, so we don't need to worry about mediation here. The only procedural step you have to take before you lodge your appeal is you have to speak to a mediation advisor and obtain something called a mediation certificate. As I said, you don't need to worry about that just yet. This is really just to show you what forms you need to download and how you need to go about completing them. So let's go on to the First Tier website. Now, what we have here is, this is essentially the portal whereby you can access information about the tribunal. So it gives an overview of what the tribunal can consider. So it's important to bear in mind the tribunal's not there to deal with, if you like, complaints against local authorities. It's there to deal with challenges against their decisions in respect of all of these things here. And they're the things that I've just outlined. It tells you who they are, and it produces here under the tribunal information the various information that you're going to need. So this is quite useful, how to appeal a special needs and disability tribunal, and that's a DVD that you can also access from the SEN4U website. And what that is essentially is just providing, here's the actual page itself. This is essentially, it's quite old but it's quite useful. This is kind of a bird's eye view of what a tribunal looks like from the perspective of the judges, lawyers, parents who've accessed it. So if you're going to tribunal, it is well worth having a watch of that video. If you're not happy with the tribunal, there's a complaints procedure that you can access, and that's all fairly self-explanatory. There's also something called procedural rules. Now, the tribunal, although it's a fairly informal process, it's still governed by something called the Health, Education and Social Care Chamber Rules. Now, they can be downloaded by clicking on this link here, and just to show you what they look like. So this essentially governs the procedure of the tribunal. It deals with the duties of the parties to the tribunal under what's called the overriding objective, and that's here under Rule 2, you'll see. It also has something quite important here under Rule 5, which is the case management powers of the tribunal. So that's where the tribunal can make directions in respect of how evidence is to be given, perhaps if evidence is to be excluded, if a party is to be excluded for breaching directions, and it's also where you go if you want to ask the tribunal for something. So Rule 5 gives the power a general duty to regulate its procedure and deal with requests that are not necessarily covered by the specific rules. And you have then general rules that set out how essentially a tribunal is going to be conducted. So directions, so just to understand what a direction is, when you register an appeal, the tribunal issues what's called standard directions. And those standard directions tell you when you can expect to receive a response to the appeal from the local authority and when both parties have to file their evidence and things like attendance forms and, if necessary, the changes that are being sought to the actual education, health and care plan through what's called the working document process. It also deals with situations where perhaps a party has failed to have regard and follow the directions. That's Rule 7, and there's powers for the tribunal to strike out parties from the proceedings under Rule 8. It's worth having a look at this and just being familiar with it. But this, essentially, these rules here govern the way the tribunal will manage your appeal. Then we go into the forms. So in the forms section, this is where you'll get all the information you need, really, to be able to register your appeal. So let's just have a little run through and see what's here. So the SEN Tribunal also deals with claims of disability discrimination. So if you want to bring a disability claim, these are the forms to be completed if you're the parent or, as I've said in earlier videos, the young person where they're 16 plus can also now bring their own claims. The request for changes form, so you're aware of this, if you want to do something, to submit something, then you fill in this form and you send it to the other party in the tribunal. And so what you can do here, just to give you an example, if you have a report that you want to submit after the further evidence deadline, you first ask the other party if they're happy for it to be admitted. You give them maybe a couple of days to respond. Whether they respond positively or negatively to your request, you then submit a request for changes form to the tribunal, say that you want to submit the document as late evidence, enclose the other party's response, and the tribunal will make a decision, and you use that form. And just to show you what it looks like, here's a request for changes form. So you'd fill up in this box here your child's name, the appeal number, the local authority, the type of appeal that you're currently in the middle of, and you provide details like the hearing date, and if applicable, the response, the date the local authority's response was due, and then you identify here. Now these here, in these little boxes, if I tick them, these are the directions, the standard directions that the tribunal can use using its case management powers that I've just talked about under Rule 5. It might be something different, and that's under the other box. So for example, if you want to provide additional evidence, you put that in other. And you would just simply state here in this box, so let me type something out. So to submit the EP report of Dr. Small, which was not available at the further information deadline. It's as simple as that. And then you set out here your reasons. So you would say something along the lines of, you know, the report is relevant to determine the issues in dispute, and you've asked the local authority to their views, and they've either given permission or refused. And if they refuse, then it's up to the tribunal to decide if they're going to allow that evidence. So that's just a request for changes form. If you reach agreement with the local authority and don't need to then continue the appeal, then you have what's called Form Send 8, and that allows you to withdraw the appeal or the claim if it's a disability discrimination claim. And again, fairly self-explanatory. Download it, send it to the tribunal, and then your claim would be withdrawn. Attendance form. So when your appeal is registered, you'll get a deadline for filing the attendance form. Now, the attendance details can change throughout the proceedings. The important thing is just to comply with the initial deadlines to file these forms, and if you want to change your witnesses at a later date, that's when you would submit a request for changes form. So the attendance form, again, you can download it. Very straightforward, very simple to complete. You just put your child's name at the top, you'd put the appeal claim number, if the claim number refers to DDA cases, your name, if there's a second parent involved, their name. You'd identify if the child is attending the hearing. You would also, if you've appointed a representative, you'd put their details in here, and then you can put your witnesses' details in the next 3 boxes here. Now, you can bring 3 witnesses to the tribunal. If you need to bring more, then you have to make an application for a 4th or 5th witness. The tribunal will grant those applications only in exceptional circumstances, so you'd have to be able to demonstrate why you can't provide the evidence either in the written format or why the case is exceptional, that it needs to have more than 3 witnesses attending the actual hearing. And indeed, if there's a particular form, if you do want to bring additional witnesses, called Form SEN 7, where you provide the details of your further witnesses. So that's the attendance form. The young person can also complete an attendance form where they're bringing the appeal. The local authority has to complete an attendance form, and it generally will submit that when it submits its response to the appeal. Now, there's some expenses that you can get from going to the tribunal. And this is the claim form that you would use, and you complete that at the end of the hearing if you want to try and recover some expenses from the actual proceedings. And the tribunal issues guidance in Form SEND 15, which tells you the circumstances upon which expenses can be recovered. And generally it's these things that I'm going to highlight here. It's travel expenses, no first class I'm afraid, and mileage. You have to send your claim within 30 days after the hearing, and the tribunal will then consider whether to pay them. Witnesses can also seek expenses for their travel as well. If you've lost your travel receipts, then you can still make an application, but you'd have to provide an explanation as to why that information is missing, and the tribunal will then take a view as to whether they accept that. The application for review form is not something that you need to worry about at this stage. This is where you want to challenge the final decision of the tribunal. So you can ask for them to review it, you can ask them to set it aside. The mediation certificate, which I talked about earlier, you need a mediation certificate. They look like this. It's a standard form that's been utilised. You need your mediation certificate to be able to register your appeal to the tribunal. Now, you get this certificate from the mediation provider that's been commissioned by your local authority. They're wholly independent of the local authority, and for all appeals other than where you appeal only against Section I, the named setting, you need to have a mediation certificate before the tribunal will accept your appeal. Key documents here for parents: if you want a witness to come to a hearing and they've refused, then you can ask for a witness summons, and those are part of the tribunal's case management powers. Now, in order to ask for a witness summons, what you have to do is first write to the proposed witness, tell them why you want them to attend the hearing, give them the date, and ask them to provide a response to you in writing, perhaps within 7 days. If they respond or don't respond, you would then submit your request to the tribunal. So sometimes it's important to witness summons perhaps people who can give material evidence about your child, but they may be frightened by adverse consequences from the local authority. And then we get to the 2 major forms that you're going to have to complete if you're going to be going to a tribunal. So there are 2 forms that the tribunal uses, and it's important to fill in the right one. So you've got Form SEND 35. Now, that is the general appeal form. So you use this form for all appeals other than refusals to secure EH needs assessments, and that's called Form SEND 35. Now let's have a look at SEND 35. So this form sets out essentially details about the appeal that you're going to be lodging, and the tribunal provides some guidance as to what they're looking for. So let's actually have a go now at completing this form. So here we go. So in the first instance, who is the child about? So it's going to be either a child or a young person. So let's in this instance say that it's the child. The only difference is, if it was a young person, then the young person can obviously bring the appeal in their own right, and subject to their mental capacity, they don't need their parents' permission to bring the appeal, and the parents don't actually even need to be involved. So let's put in the surname. We put our first name in there as well. Let's scroll that down. So you put your details in. I'm a male. and then we put in our date of birth, and then you identify here in section 2 what you're actually appealing against. So there's lots of different boxes. So the first one, the local authority secured an assessment but refused to make an EHC plan. The local authority has issued an EHC plan following an EH needs assessment. The local authority has refused to secure a reassessment of needs. The local authority has carried out an annual review. The local authority has refused to amend the EHC plan after a reassessment. The local authority has decided to cease. So you always fill in one of these 6 boxes here, and then at that point you have a choice of these 3 boxes or this singular box. So let's see how that might play out in practice. So what we'll do is the local authority has carried out an annual review, and in considering the education, health and care plan, I am unhappy with section B, section F and section I. And I disagree with section I because I don't agree with the school or college that's been named in the plan. Now, if the local authority at this point hasn't named a setting, you tick the last box. The local authority has not named a college or a school. And in those, you can still appeal on that basis. And the tribunal would ask you to just either name your proposed school or to describe the type of school that you think would be suitable. So in this instance, let's leave it as a type of school or college, and then we can fill it in. So it's quite straightforward just looking at it. It's a tick box exercise. That's quite standard for people to be able to do that. The key thing here is just identifying the type of appeal that you've got. But that should be self-explanatory when you look at the letter that you've got from the local authority. Moving on, so if you're appealing against section I, this is where you would insert the details of the school that you're proposing. So in this box here, you'd identify the name of your school and you'd put its address here. What the tribunal then also asks for you to do is to confirm in this box that you've contacted the school and you've asked for a place. And the tribunal will generally want you to submit what's called a provision of place form to be able to demonstrate that a place is actually available for the child or the young person in the setting. Because other than in exceptional cases, and we don't need to go into that today, the tribunal can be limited as to what it can name in section I unless the setting has offered a place. Now what we're going to look at here is, so in this instance the local authority has not named a particular setting, they've simply named a type. And let's, for the sake of argument, just say they've named a special school. So that's a maintained special school is the described type. What we would say is we don't agree with it, we want a special school for children with autism. And that's because that's the designation of the school that you want. Now, since April 2018, the tribunal has also had the power to make recommendations in respect of the health and social care provision that's set out in sections C, D, G and H of the EHC plan. So what that means is, as part of the pilot, the tribunal can evaluate the issues that you raise with them. So if you do disagree with the health and social care provision and description of need, you simply tick these 2 boxes. Now we don't need to complicate matters today, this is just to show you that that's where you would put it. And the reasons for appeal, section 3. So this does not need to be an act of great draftsmanship. The tribunal is an accessible forum. They're not expecting people to be great lawyers. What they're expecting to know from parents and carers, if you like, are the key ingredients of the claim or the appeal that you're bringing. So in this instance, I've said that we're appealing against sections B, so that's the description of the child's difficulties. We're appealing against section F, that's the special educational needs provision. And we're appealing against the description of the school named in section I. So let's just have a little look by example as to what you might include in these sections. So I want to tell the tribunal first why I'm bringing this appeal. So we might just say, I disagree with the local authority's EHC plan because it fails to properly specify Mark's needs and does not provide him with the correct level of support to be able to make progress and to have his needs met. I also consider that Mark requires a special school for children with autism. Now, that is the context. So, as I said a moment ago, you don't have to provide a great level of drafting here. You just want to be able to demonstrate this is why you're in this situation. And the tribunal at this point will then ask you to give the information in respect of each area that's in dispute. Now, again, at this point, you might not have all the information available because you might be looking to instruct private professionals to give you information about the changes that should be made to the EHC plan. So what we look at here is we look at the description of the difficulties as currently set out in the EHC plan, and what we say to the tribunal is things like this. The EHC plan fails to properly describe Mark's cognitive difficulties, and in particular that he is not making progress in literacy-based subjects. So that might be a legitimate concern. So this is what this is saying is, if we can spell cognitive correctly, what this is saying is that Mark's got good cognitive ability, but he's not making progress, and that needs to be set out in section B under the cognition and learning section. We might also want to say Mark has a developmental language disorder, and this is not specified in section B, despite advice of the speech and language therapist. So you get the gist of what you need to do here. So if in doubt, a good way for parents to set out the concerns here is to look at section B of the plan and to tick what you agree with and what you disagree with, and to identify what's missing. Now, you know your child better than anyone else, so you should be able to do that and dot them out as bullet points. Because what you can also do, you're not confined to the boxes. If you want to say more, then what you just simply do is go into Microsoft Word, which we'll do in a moment, and you just say, please see attached grounds. Okay, what you would then do is you go into Microsoft Word or a Word document, and then you would put grounds of appeal, continued, section B. I believe it should include, and then list it. And you would submit that with the appeal form. So you don't have to, make it, as I said, a great work of draftsmanship. The tribunal just has to really understand why you're looking to appeal. And perhaps if you are in doubt about what needs to go into the EHC appeal, then you can seek legal advice. But the purpose of these forms is not to make the process too difficult, too cumbersome for parents. It's actually to make it easier. So they're not expecting you to quote chapter and verse of either the law or the code of practice. So we come to the next bit in the form, which is the description of the special educational needs provision. So here we might say the EHC plan is not specific or quantified. So all EHC plans have to specify clearly the level of support that the child's going to get, and to specify therapies, the frequency of them, and so forth. So we're going to highlight to the tribunal, we've read our EHC plan and we're not happy with it. So we're going to give the tribunal a flavour of the issues that we want them to look at. So in this instance, the EHC plan is not quantified in terms of the teaching assistant support Mark requires, he has been allocated no designated support, and we feel he needs 32.5 hours of adult support. Mark also needs quantified speech and language therapy, and to include both direct and indirect input from a speech and language therapist. That's it. Again, this may be just something that you might in conversation have with the school or professionals or the local authority. As I said, the tribunal's not after a great drafting exercise. What they're looking for you to do is be able to tell them, look, this is the dispute. So when they pick up the appeal papers, they can say, right, the two issues in this case that are up for dispute are the level of support that Mark's been allocated and the level of speech and language therapy. Now, one of the things that I would say at this point is, this is where you need to then think about the evidence that you've got, because you can then say to the tribunal, here, in the box that follows, so the expert evidence provided by Mark's annual review, because that's how this appeal arises, it's following the annual review, shows that he requires full-time support, 32.5 hours, and a quantified package of SALT. That's an abbreviation for speech and language therapy support. And then you can say, see reports of bum bum bum. Absolutely, that's it. So there's no mystery here. So the local authority hasn't named a school, so we leave that one blank on this particular occasion, and that's the next box. And I prefer my choice of school or type. We say, so Mark has a diagnosis of autism and requires a setting that can provide ASD specific provision, including the application of, let's say, autism strategies like CERTs and intensive interaction, requires specialist staff who are trained and experienced in autism, and will have AET, ASD training at levels 1 to 3. So this is essentially the core information that will then enable the tribunal to work out, right, okay, these are the things that we're going to have to ask questions of witnesses once all the evidence has been produced. And this is just an opportunity at this stage for you to set out, if you like, the nuts and bolts of your case. You'll get a further opportunity at the further information stage, which I talked about earlier, to submit all your substantive evidence, and if necessary, to make further written submissions or fuller written submissions, which you can do using Word or even handwritten. Section 4 of the form, that's where you put in information about the changes that you're asking the tribunal to consider in respect of the health and social care needs and provision, and you would just identify that's not an issue obviously in this example, but you'd identify here perhaps the local authority's not considered a health report in time, perhaps there's a health provision that's not been recorded despite being in a report from, say, a paediatrician, perhaps there's a social care assessment that's not been referred to, and perhaps they've not referred to the latest, I don't know, direct payment or social care assessment that's relevant and changes the child's social care provision. You deal with those in each of these boxes here if they're applicable. You then get to section 5, and section 5 you essentially insert the name of the local authority you're appealing against. So let's stick in the great nice folks of Hertfordshire County Council, and you put in the date of the decision. Now you have 2 months to appeal, You get a further 30 days if you get a mediation certificate, if you need one. So you don't need one if your only appeal is against Section I. But other than that, it's 2 months to get the appeal in. And if you're late, you can still submit the appeal, and you can ask the tribunal to exercise its discretion using the SENDIST rules and its case management powers under Rule 5 to extend the deadlines, and you'd have to hear explain, my appeal is late, and give the reasons why. And sometimes there might be many reasons why an appeal is late. It could be because perhaps your child's been excluded from school and you've had to deal with the stress of that. It could be that you didn't receive the documentation in time. Whatever it may be, this is your opportunity in this box here to be able to explain to the tribunal why the appeal should still be admitted and why the tribunal should exercise its discretion. And here you want to be referring maybe to the tribunal rules. So as I talked about at the very beginning, there's an overriding objective, which is in Rule 2 of the tribunal rules, and that says that the tribunal has to look at, the needs of the child, look at fairness, and try to act in the best interests of all the parties, but having particular emphasis on the child. So you could say, it prejudices the child's education, perhaps maybe because they're out of school, maybe they're in an unsuitable school, if the appeal is not admitted late. You then put the details in Section 6 of who's actually making the appeal. So for children under 16, it will always be the parent. You've got the young person if it's 16 plus, and you've got the alternative person. So the alternative person is someone who is bringing the appeal in the best interest of the young person because they don't have mental capacity to bring the appeal themselves. So in these, again, quite straightforward. You then set out the details of those that are bringing the appeal. If there are other people who are involved in the appeal, that's where you complete Section 7. So maybe you've got a deputyship order in the respect of a young person. Perhaps you've separated from your partner and your partner needs to be included because they have parental responsibility. You'd put those details in these boxes here. Now, the tribunal makes provision here for representatives. So in the first instance, you get the opportunity to include an advocate if you have one. So that's someone who's really going to help you maybe express your views at the hearing. So you'd put your advocate details here. You then also got your representative. So this is someone like myself, a solicitor, and your solicitor would normally complete this for you if you've instructed one. But if you haven't instructed one, and you've got someone who's going to represent you at the hearing, this is where you'd input their details. Now, what you do have to decide is who's going to get all the paperwork and deal with correspondence from the tribunal, and that enables you to do that in these boxes here. So if you're legally represented, your representative would get everything generally, and they would manage the appeal on your behalf. However, if they're not acting for you, if you've not got a lawyer acting for you, then it would obviously be parent 1 or parent 2 or the young person. The tribunal is also accessible, so it will need to make adaptations if you've got disabilities. So, for example, the provision of interpreters or signers. If you're a wheelchair user, it will need to be accessible. In this box, in Section 8, you need to tell the tribunal if those are issues for you, and they will then make the necessary arrangements. The tribunal can also deal with cases on the papers, but both parties generally have to agree that that is the case. In most cases, you wouldn't want the tribunal to deal with cases on the paper because of the nature of the issues that are going to be raised, particularly where you're appealing against the contents of the EHC plan. Those can often be quite complex appeals, where the tribunal would benefit from hearing oral evidence from both parties. And you can ask the tribunal if they do have an earlier hearing date available, you can ask them for that. At the moment, you're looking at tribunals being heard within a 20-week window from being registered. That's slightly above what their general timescales are, which are 12 weeks, and that's because of the sheer volume of appeals currently being managed by the tribunal service. If you've got another tribunal claim, sometimes they try to consolidate them to save you time and resources. You can then join that claim in this box here. When you submit the form, they give you a checklist of the things that you have to send with it. So you have to send a copy of the letter that you receive from the local authority, which gives you your right of appeal. You have to have the mediation certificate, if that is applicable. You have to have your reasons for making the appeal, so that's section 2 of the form, and any other attachments in Word that you've got and filled in. You need to send a copy of the EHC plan and the appendices if you've got them, and then you need to sign the appeal form in the relevant box here. What you then do is you can either send the form to the tribunal via the post, and that's their postal details here, or you can send it via email. We would send it via email, and it goes to that address there, send@hmcts.gsi.gov.uk, and you can send that in a simple email. You then, the other thing the tribunal has in the form is that you can put here the documents that you submit with it. So in this schedule here, so if you've got the appendices to the EHC plan or the annual review documents, or you've got specific expert reports that you want to have admitted at this point, this is where you list the information here, and essentially then you send it off to the tribunal. The tribunal's registration team will acknowledge it if it's via an email, via a standard email, and then you can probably wait up to 10 days to have the appeal itself registered. And that is how you register an appeal. Now, going back to the main screen, we've now looked at a general appeal form. You've then got Send Form 35A, and that is where you're lodging an appeal against the refusal to carry out an EHC needs assessment. So if we look at this particular form, it's the same type of form. So it's just very subtly different, because at this point, obviously, the child doesn't have a plan, and so the boxes that are regarding your dispute about section B, F and I are not applicable. So the tribunal is going to look at very specific information in respect of this form. So just bear that in mind. If you want to appeal against the refusal to assess, it's Send 35A. We're going to look at that form now. So you've already seen this form. It's the same as Send Form 35, except section 2 applies the law specifically related to EHC needs assessment. And what they want here is your assistance in addressing the legal questions. Now, they're not asking you to be lawyers here, but what the tribunal has to do is apply 2 different stages. And these are legal questions, and they are translating them in the form in layman's terms, which is quite helpful. So let's just have a little look at the first test the tribunal applies. So the legal test for an EHC needs assessment is set out at the very beginning of the form. You can see it here. And in the box below, question 1 that they ask you, whether the child or young person has or may have SEN. So what you would write in this box here, if your child's been diagnosed with particular difficulties, this is where you'd identify that diagnosis. If they haven't been diagnosed, then what we're talking about here are specific concerns in respect of their cognition and learning, their speech, language and communication, their social, emotional, mental health needs, or their sensory and physical needs. This is where you would identify them. So the first box, this one, is the difficulties that you know your child has. The next one is essentially, what further difficulties do you think they have that may require the assessment? Because that ultimately is what the tribunal is going to be a look at. Are there things that we need to clarify? And the clarification would come from an EHC needs assessment. So you didn't put those boxes as appropriate to your particular child's circumstances. The second question that you'd have to look at is, why do you think the child requires an EHC plan? So in this particular instance, what it's probably worth thinking about is, well, you can say, what it's worth thinking about in this particular case are the resources that have been currently deployed by the educational setting, and what additional resources you think are required over and above those resources. So, for example, and I'm going to give an example of what this all might look like. So, let's first of all go back to the question 1. So, Mark has a diagnosis of autism. He is working 2 years below his chronological age of, let's say, 10 in literacy and numeracy. Mark struggles to make friends and finds the classroom environment challenging because it is too noisy. Okay? Mark has not made progress despite his school, and perhaps you'd name the school here, taking steps to meet his needs. Mark's difficulties have been identified in the expert reports of. And then you would list the reports that you're going to refer to. Now, the next box, Mark has sensory needs, and I consider he requires assessment from an occupational therapist. And so you just list here, if your child hasn't had input from experts, this is where you would list that this is why you think they need to have an EHC needs assessment. Now, whether the child may require an EHC plan, you would say, so Mark has been allocated 11.5 hours support by his school. This is insufficient to meet his needs. He requires full-time support, totaling 32.5 hours. This is above the resources that are available to the school. And that, you might also then talk about, you know, Mark requires specialist input to address his literacy and numeracy difficulties. This needs to be timetabled and quantified. Mark may need specialist teaching in these areas. To date, such provision has not been provided through the school-based resources. So you can see what you're doing here. These are all issues in both forms. These are all things that parents can more than competently manage. So to kick off an appeal is actually relatively straightforward. You just have to be able to, if you like, put your arguments together. But you know, if you're in a, you know, if you're having a drink with your friend in Starbucks and you're talking about, you know, my child's difficulties at school, these are the kind of things that you would rattle off in that conversation. So don't be intimidated by the thought of having to go to a tribunal to have your child's needs enforced and provision provided, because quite frankly the statistics will tell you that local authorities are absolutely awful at responding to and managing SEN tribunal appeals, and they generally lose 90% of these cases. So that tells you all you need to know. So that's just some examples of what you would have in those sections. We then get to section 3. That is the same as the last form. This is about the local authority that's made the decision, the date the decision was made, whether you're in time, you see, whether you've got a mediation certificate. Now, for a refusal to assess case, you will need to have a mediation certificate, so you must speak to the mediation advisor promptly so that you can kick off your appeal. Section 4, now for refusal to assess cases, the SEN Tribunal generally hears them on the papers, but sometimes it will agree to have an oral hearing. So if you feel that you're not able to communicate effectively through written means, then ask for an oral hearing. So perhaps maybe you've got a learning difficulty yourself, maybe you don't feel confident at being able to express your case in writing. In those circumstances, you set out here that you don't agree to a paper hearing and that you want an oral hearing, and you give your reasons here. And generally speaking, the tribunal will allocate it an oral hearing. If you've got another claim going, that's where you provide the details here. Again, the reason for that is so that the tribunal can try and consolidate them. And again, you've got the same box, section 5, which is about who's making the appeal. Is it the parent, is it the young person, or is it the alternative person? And you provide in this aspect of the form, again, the personal details of the person bringing the appeal and anyone else involved in the appeal or who needs to be involved in the appeal in section 6. Again, you get the opportunity to put details in of the advocate you've appointed or the representative, and they provide their details in that part of the form as well. And again, you decide who is going to deal with the appeal papers. And section 7 and 8 are again exactly the same as the last form, in the sense that you'll get asked if there is to be an oral hearing, then you can provide the tribunal with details about the adjustments that you might need to have made. For example, again, an accessible venue, signer, interpreter, hearing loops, whatever it may be. So again, section 8, you've got a checklist of information here that you have to send with the appeal form. So you've got your letter that refused the EH needs assessment, you'd have the mediation certificate, you'd have the reasons for the appeal. Those will be set out in the form, or again, you can set them out in a separate Word document or handwritten document, whatever you feel comfortable of. And then at section 9, you would sign, where applicable, you would then sign the form and send it back to the tribunal. Again, that can be sent electronically or it can be sent via the post. If you're going to send it via post, then it's always better, I think, to send it by recorded delivery, so you know that the tribunal has received it. I personally prefer to always send them by email, because you can then track them with a read receipt and a delivery receipt. And again, you have the opportunity in this part of the form to put in the evidence that you've got at the moment. You don't have to submit everything at this point if you haven't got it. You'll be given a deadline for further information by the tribunal when it issues the standard directions. And they issue the standard directions in all types of appeals when the appeal is first registered, and that's usually within 10 days of sending these forms to the tribunal. So that was just a quick video to show you the forms that you need to complete when you want to register an appeal with the First Tier Tribunal. If you want to download some precedent documents to refer to, then there are some on the SEN website. I hope you enjoyed the video. Share, comment, like, subscribe as always. I'm Mark Small. Let's make SEN great again.